You don't have to. We're going to be getting started in about 3 minutes, so if you have your phone with you, go ahead and turn it off. Not silent, not vibrant, so you're going to keep this off.
Good morning to everyone. First case this morning is State versus Griffin, and we will hear from the appellant.
May it please the court. Mr. Chief Justice, Associate Justices, my name is Joe Finarelli with the Department of Justice here on behalf of the state. I'd like to reserve 5 minutes for rebuttal. The majority below erred because it failed to recognize the distinctions between the circumstances presented by this defendant and those the court addressed in the Grady III opinion, and therefore erred in reversing the trial court's 30-year SBM enrollment order. Now, clearly at the time, the court did not have available to it this court's recent opinions in Hilton and Strudwick, and I'll address those shortly. Mr. Griffin was convicted in 2004 of first-degree sex offense. He sexually abused the 8-year-old daughter of his live-in girlfriend over a period of 3 years until she was 11. He digitally penetrated her. He penetrated her with his penis, and he used a vibrator on the girl. At the time of his sentencing, there was a mental health deficit, according to the pre-sentence services report, which included a provision that said it was difficult to determine his potential for a pattern of inappropriate sexual behavior. At sentencing, the judge recommended SOAR treatment for sex offenders within the prison system and recommended that Mr. Griffin undergo that treatment. At the time of the SBM hearing that was conducted in 2016, there was a static 99 that had been performed, which showed that Mr. Griffin was a moderate low risk of recidivism. There was testimony from the probation and parole officer that the satellite-based monitoring device was water-resistant, could be worn under clothing, required 2 hours of charging. At that time, I think it was 2 times a day was her testimony. That there was no interference with physical labor, and that it only tracked the location of the offender, not the activities of that individual. Mr. Griffin had not violated the terms of his post-release supervision, but there was also testimony that he had not completed or even attended the SOAR treatment that was recommended at the time of sentencing. Neither party made a request for a particular length of time for SBM enrollment, and the defendant did not put on any evidence in that case. The state's evidence came in strictly through the probation and parole officer. The trial court, in ordering 30 years of satellite-based monitoring enrollment, took note of the fact that defendant had failed to complete that sex offender treatment while in custody, that he had taken advantage of the victim's age and the position of trust that he had in the household, that the period of abuse was 3 years for such a young child, and concluded that the public's right of protection outweighs the de minimis intrusion upon Mr. Griffin's Fourth Amendment rights. In applying the Fourth Amendment framework, the court below was looking at what it had available to it, which was the majority opinion of this court in Grady. I'll refer to that as the Grady 3 opinion. I think everybody's familiar with it. Since that time, this court has changed direction, might be the appropriate word, but has taken a different perspective with respect to the reasoning of the majority in the Grady 3 case. And as a result, and I think in conjunction with the narrow and expressly narrow holding of the Grady 3 opinion, it was appropriate for this court to have done so in Hilton and Strudwick.
Is there enough direction in Hilton and Strudwick for this case to simply be remanded to the Court of Appeals for reconsideration in light of those opinions?
I'm sorry, Chief Justice, your question was, should the court do that, or is
there enough direction, although not on all fours, with the particular offense that the defendant here is convicted of? He's not classified as an aggravated sex offense.
Correct.
But is there enough direction in Hilton and Strudwick that this court could simply remand to the Court of Appeals for reconsideration in light of those cases?
I mean, yes, certainly it could. And the court did so when Grady was issued. It did so in this case and the Gordon case, which is coming up next, as well as several others. That is certainly one option, to remand to the Court of Appeals to evaluate Hilton, Strudwick. What does that mean with respect to this particular offender? Because admittedly, neither of those cases addresses the specific scenario presented by Mr. Griffin. Mr. Griffin is not an aggravated offender, just like Grady doesn't address Mr. Griffin's circumstances either, because Grady was an unsupervised recidivist. And the court's holding in Grady 3 specifically limited the consideration to that category of offenders.
Can I just follow up on what you've just outlined for us? Given that, as you said, this defendant doesn't fit into the category of offenders that was in Grady 3, does not fit into Hilton or Strudwick, what's the principled reason for deciding which precedent should apply in this case?
The principal reason for deciding which precedent should apply? I mean, I'm not sure I understand the question. Are you asking which precedent would apply? below if it were remanded?
Or just, as you are arguing to us today, which precedent should apply to this offender?
Well, I think the most recent iteration of the Fourth Amendment analysis from Hilton and Strudwick is an indication of the court's position with respect to that analysis. The Grady III opinion clearly has not been overruled, but I do think that Hilton and Strudwick have identified the limitations of that opinion, the limitations of the holding of that opinion, and have taken a different perspective of the analysis that the majority in Grady III relied on to reach the conclusion that it did. And I don't think anything prevents this court from doing so again here. The court could look at the same set of circumstances and apply a different framework for an offender in Mr. Griffin's category than it did the offenders in the aggravated offenders in Hilton and Strudwick or the recidivists who are in Grady.
Can I ask you about one specific aspect of the difference? And that is, in Hilton, the order was for lifetime satellite-based monitoring. And in this case, it's for a term of years.
Correct.
And what I want to know is your position with regard to the impact of the new statute that the General Assembly has passed, and whether or not the issue of whether in Hilton, because it's lifetime order, it can be reviewed at some point by a court, whereas under the new statute, can this sentence of 30 years be reviewed by another court?
Taking your second question first, no, I agree with you. The new statute that will take effect 3 weeks from now does not provide for judicial review of an offender in Mr. Griffin's circumstances. As far as the first question of what impact does the statute have, I think the answer is, frankly, there isn't any. Whether that was an oversight by the General Assembly that will be fixed in a technical corrections bill or whether that was intentional isn't clear, at least to me as I argue here today. But the new statute does not address folks in Mr. Griffin's circumstances who have already been subjected or ordered to enroll in satellite-based monitoring for a term of years. There is no judicial review provision for that group of offenders, and there is no 10-year cap on enrollment for those offenders because they don't fall into the categories that the legislature has now established, where lifetime folks are reduced to 10 and term of years offenders can get no more than 10. Mr. Griffin doesn't qualify under either of those new evaluations.
And would you agree that under the U.S. Supreme Court precedent, the availability of judicial review of the imposition of this search is one element in determining whether or not it's reasonable under the Fourth Amendment?
Yes, I would concede that that is an element to be considered in the analysis, yes.
Let me ask you this. So the definition of aggravated offense is engaging in a sexual act involving vaginal, anal, or oral penetration with a victim who is less than 12 years old. Mm-hmm. Is that, in fact, what Mr. Griffin was convicted of?
Technically, I think from the facts, yes. However, the offense he was convicted of, the Court of Appeals in the Davison case established that in order to consider whether someone qualifies as an aggravated offender, you have to look at the elements of the offense, not the underlying facts. So on that basis, the first-degree sex offense elements don't require penetration. It does require a sexual act, but it does not require as a condition penetration, oral, vaginal, anal, in order for the offense to be charged. So I think that from the courts, the appellate court's precedent on this point, it would not qualify as an aggravated offense under that precedent. The underlying facts, if those were considered, given the circumstances here, an 8 to 11-year-old girl with allegations that were undisputed at the plea hearing of vaginal penetration would qualify under the concept that I think Your Honor is framing. So with respect to the Fourth Amendment analysis, Hilton and Strudwick, again, being simply the most recent discussion from the court about the Fourth Amendment analysis, has discussed several different factors. It concluded that the state's interest in protecting the public from sex offenders is paramount. It identified that the purpose of satellite-based monitoring is to protect the public from sex offenders, and cited to 14208.5 of the general statutes, where the legislature at the time had, and I think still today, has explained the purpose of the registration and, by association, the satellite-based monitoring provisions. This court concluded that the SBM assists law enforcement in solving crimes and deterring recidivism. It considered that the satellite-based monitoring is effective in reducing recidivism, citing to empirical studies from California that proved that, or that concluded that based on the information that it had evaluated, and had also identified that there was no need to prove efficacy on an individualized basis. Now, that may have been because of the facial aspect of Mr. Hilton's challenge, but the court did observe that in the course of its opinion. It indicated that the privacy interests for sex offenders are severely diminished during periods of post-release supervision and are diminished thereafter by virtue of the sex offender registry status and obligations of those convicted of sex offenses. And it also concluded that there were no significant affirmative disabilities or restraints by virtue of the monitor and having to wear the monitor for the period required. In the Strudwick case, the court generally followed what it had said in Hilton. It highlighted the evidence before that court that satellite-based monitoring tracks the offender's location, not what they're doing there. There was similar testimony here from the probation and parole officer on page 7 of the transcript. The Strudwick court found that the trial court had found the device was a relatively small and unobtrusive one, and that the defendant had not challenged any findings of fact made by the trial court. Similarly here, the defendant has not challenged the findings that were made below to support the trial court's ruling with respect to at least any specific facts. I think they challenged the sufficiency of the facts collectively, but not the individual facts as found. And the Strudwick court said that the purpose of SBM is to assist law enforcement in preventing and prosecuting future crimes committed by sex offenders. So in considering that framework in the totality of the circumstances here presented by Mr. Griffin and the circumstances of his offense, the conclusion that the court should reach is that this is a constitutional application of the Fourth Amendment with respect to Mr. Griffin. Now, he's made an as-applied challenge. I know that the court, I think it was Justice Earls in Grady, you discussed that it wasn't necessarily the label that one puts on it. What was requested and what relief is ordered is, the court determined what it determined and issued and ordered the relief that it did. But Mr. Griffin is simply requesting that this court find that as applied to him, satellite-based monitoring is unconstitutional because of the failure of the state in their mind to prove the reasonableness of the search. And I think based on what the court has decided recently in Hilton and Strudwick, And it could, if it were to follow that reasoning, could similarly decide that on these facts, Mr. Griffin requires satellite-based monitoring for a period of 30 years. In their, I believe, in recent briefing with the court, or submitted to the court, defendants have suggested that they should receive, the court should lower the term to a 10-year term similar to what the statute would provide if Mr. Griffin were enrolled in satellite-based monitoring today, or as of December 1. And I would simply note that that's the same sort of judicial legislating that they criticized in Hilton in the context of the majority at the Court of Appeals severing the for life provision and ordering Mr. Hilton to be enrolled in satellite-based monitoring for simply the period of his post-release supervision. Now, clearly, the court went a different direction and didn't address the severability issue, but it's the same sort of legislating from the bench that I think the court has historically tended to avoid. Failing any other questions, I will reserve the remaining time for rebuttal, but anything further? Okay, thank you.
Thank you, counsel. We'll hear from the appellee.
May it please the court. Good morning, Your Honors. Jim Grant with the Office of the Appellate Defender on behalf of Mr. Griffin. I'd like to center for the court what's at issue in this case, and I think Mr. Finarelli has sort of teed me up a little bit in his conclusion. This case, unlike the cases that have come before, is simply about the constitutionality of this order. This is an as-applied challenge. It has always been an as-applied challenge. We are not concerned in this case about the broader constitutionality of the SBM regime as it was, as it will be starting December 1st. This is about the order in this case. An order that imposes an unreviewable, continuous warrantless GPS search of Mr. Griffin's location, which will track his every movement for the next, or whatever remains of the 30 years left on the order. Mr. Griffin is a middle-aged man with no prior felony history other than his single conviction, who the state's own risk assessment shows is a low risk to reoffend, and who has no ongoing relationship with the state now or in the future. He is not on post-release, he is not on probation, he is certainly not incarcerated. And Mr. Griffin's single prior crime would not have been deterred by SBM because it occurred, as Mr. Finarelli noted at the start of his argument, in his own home with a known victim. In light of what this court has said, going all the way back to Bowditch about the non-punitive nature of SBM, and what it has said in Grady 1, Grady 3, Hilton, Strudwick about the various factors and considerations that are in play in doing this analysis, it is our position that Mr. Griffin is subject to an unconstitutional search. And we have that position because, as is familiar in these SBM cases at this point, we have a balancing to determine the reasonableness of a search. On the one hand, you look at the intrusiveness of the search on the enrollee's privacy interests, and on the other, you look at the need the search has for the advancement of that legitimate government purpose. And I think, weighing those factors, we have a bright line rule in this case, at least as it pertains to this factual circumstance. Where the state's interest in SBM, which is preventing recidivism, I think we're all on the same page at this point that that is at least the purported interest it seeks to advance. When that is the state's interest, and that interest is at its lowest in this case, because the state's own evidence shows that Mr. Griffin is not likely to reoffend, and if his one prior crime is any indication, SBM would not have been useful in the deterrence or investigation of that crime in any event. So you have a very low interest in this case on these facts. At the same time, you have the enrollee's privacy interest is at its most elevated because Mr. Griffin has no relationship with the state. Now, I understand Hilton and Grady, both of which are good law, neither of which are overruled, come to different conclusions about the sort of nature of that privacy expectation, whether it is sort of basically indistinguishable from you or I in Grady 3, or whether it is somewhat diminished in Hilton based on the compliance with the registration statutes. In any event, it is as high an interest as can be under these facts, regardless of the quantum you place on that interest. When you have a situation where the state's interest is very low and the privacy interests are very high, you have an unconstitutional search in this case, especially where the state has failed to demonstrate that there is a threat specific to Mr. Griffin. Again, the static 99 shows he's a moderate, low risk to reoffend. That is the state's chosen instrument in these cases. The state's evidence shows that Mr. Griffin is of low risk to reoffend. And when you have a low risk to reoffend combined with high privacy interests, in this case, 30 years of continuous GPS monitoring of Mr. Griffin is unconstitutional. And Mr. Finarelli talked a bit about the Hilton decision, and just by way of contrast, I think it's instructive to kind of go through the justifications in Hilton and talk about what this court identified as the justification for satellite-based monitoring for aggravated offenders in those cases, and sort of contrast them to the facts we have in this case. So in Hilton, this court noted its belief that sex offenders often pose a high risk of recidivism, although I would note Grady 3 noted that the state had not actually presented any evidence to that effect. But even assuming that sex offenders present a high risk of recidivism and that in general justifies satellite-based monitoring, well, Mr. Griffin is unlikely to reoffend by the state's own metric. So that justification is simply not at play in this case the way it was in Hilton.
So the state mentioned a mental health assessment that, I mean, you know, the facts of this case are very concerning. I mean, an 8-year-old child being sexually molested for 3 years. Should that have been considered in the assessment for satellite-based monitoring? Both the nature of the crime, an 8-year-old child, and the mental health assessment that showed some concerns, and, I'm sorry, I didn't add this, in the fact that he did not attend the SAR treatment as recommended by the trial court.
Okay, well, so a little bit to unpack there. The nature of the crime, strictly speaking, is not relevant to the determination, Chief Justice Newby, and the reason why is because that is the heinousness of the crime is absolutely an appropriate consideration in meting out a criminal sentence. But SBM is not punitive. The point of SBM is to act as a deterrent or to prevent recidivism. And so the actual facts of the crime are not particularly relevant to that inquiry, although they are fully relevant, I will concede, to the sentence determination, and Mr. Griffin spent more than 10 years in prison for this crime. As to the other information in the pre-sentencing report, I mean, I presume that would be something a court could consider, but I think there may be some, just as a factual matter, there may be some staleness issues with that. I mean, that pre-sentencing report was prepared in, I believe, 2003. You know, that was almost 20 years ago. This hearing itself actually occurred 6 years ago, so there is sort of a time dilation. You know, I don't have any issue with a court considering any of that data in making its determination, and it appears the court did in this case. But at the end of the day, there's still a constitutional threshold the state must meet. This is an as-applied challenge. It is a warrantless search. Therefore, it is presumptively unconstitutional. We're not talking about the facial validity of the enactment. That is arguably presumptively constitutional in a facial challenge. In an as-applied challenge, you have a warrantless search. That is presumptively unconstitutional, and the state must justify and has the burden of persuasion on that point. So if SBM's whole point is a civil regulatory scheme is to prevent recidivism, and recidivism is frankly not an issue in this case, well, then we turn to maybe some of the other justifications, which is that SBM is effective at helping law enforcement solve crimes. As Hilton notes, again, Grady 3 disagreed on that point, but even assuming the Hilton framework, Mr. Griffin's crime, as I mentioned, was not one that SBM would have been useful in investigating. It occurred, as you note, Chief Justice Newby, in his own home and over a period of time. So this is not a circumstance like, say, Mr. Strudwick, which this court heard recently, where you have someone attacking strangers on a greenway, where SBM, it's sort of commonsensically you could maybe see the usefulness of SBM as a law enforcement or recidivism tool. You just don't have that in this case. Similarly, SBM in Hilton was deemed to be an effective deterrent. But again, sort of taking these two factors in conjunction, if there's no risk of recidivism or a low risk of recidivism, and the only time Mr. Griffin has ever committed this sort of crime was in a circumstance where SBM would neither have deterred nor aided in the investigation in all likelihood, then the Hilton justifications are just not present. And again, I don't mean to sound like a broken record, but this is an as-applied challenge, and so therefore the court has to focus on the facts of this case. And so I contrast it with Hilton just to show that, that at SBM can be conceptually constitutional or constitutional as it pertains to some categories facially, but not in other circumstances. And when the general justification for a facially constitutional enactment simply doesn't exist, well then the enactment can be unconstitutional as applied to an individual. And I'd like to bring up the...
Mr. Grant, let me shift just a tiny bit. Mr. Finarelli characterized the nature of the intrusion as de minimis. I'm imagining that you don't agree with that characterization.
No.
Can you explain what your position is on that?
Sure. That is something that the Court of Appeals grappled with in the first wave of these cases, is how to characterize the nature of this intrusion. Is it de minimis? Is it something more? It is our position, and has always been our position, that this case, that SBM is not a de minimis intrusion. I don't think the Hilton court even really went so far as to say that it was de minimis. It may have disagreed with the Grady III court about how intrusive it is, but I don't even think the Hilton court would say that it is a de minimis intrusion on privacy. So that finding in the trial court is just simply not supported in law, really, under any of this court's decisions. And, it has been our position that it is not a de minimis intrusion, and that's not just our position, that's, again, the position of this court, at least in Grady III, but also the position of the United States Supreme Court. If you look at the Carpenter decision, if you look at the Jones decision, particularly the concurrences, satellite-based monitoring creates a record of an individual's every movement, in this case, for what amounts to the rest of Mr. Griffin's life. There's a tremendous amount of information and data that you can obtain about a person just based on their comings and goings, and I would recommend to the court Justice Alito's opinion in Jones, Justice Sotomayor's opinion in Jones, and the majority opinion in Carpenter, which I'm struggling to recall which justice wrote that opinion, but it was a majority in Carpenter that talks about how when you collect this data over long periods of time, and in Carpenter, we weren't talking about 30 years, we weren't talking about 1 year, we weren't talking about 6 months, we were talking about like a few days. And the court concluded that that sort of long-term data collection about a person's location implicates Fourth Amendment interests in a weighty sense. So any suggestion that this is a de minimis search, I think, has been rejected by pretty much every court, even if this court in particular has sort of disagreed about the extent to which the search intrudes on expectations of privacy.
But while it's your position that it is not a de minimis intrusion, wouldn't that be relative to the aspect that the defendant would have a diminished expectation of privacy in light of the fact that he is a convicted offender?
Well, so this is another point where Hilton and Grady simply don't agree explicitly. The Hilton opinion says that by virtue of enrollment in the sex offender registration program, that an offender has some lesser expected privacy interests. Grady III says, in sum, we hold that recidivists as defined by the statute do not have a greatly diminished privacy interest in their bodily integrity or their daily movements merely by also being subject to the civil regulatory requirements that accompany the status of being a sex offender. So it is our position, and has always been our position, that merely being a registered sex offender does not appreciably lower the expectation of privacy one has in their bodily autonomy, having this monitor on them for the next 30 years, and also their location data, which, again, you can extract a gigantic amount of information from if one were so inclined. So
I heard you use the word appreciably, and of course, again, that goes back to my usage of the word relative. Isn't it relative to a defendant's position in terms of an expectation of privacy, while you say the cases are beginning to have some differentiation as to where each stands relative to that relativity of expectation? Nonetheless, appreciably may be a bit far, but still nonetheless some expectation of a reduction.
our position, Justice Morgan, would be that an individual does not have really any diminished expectation of privacy merely by virtue of being a sex offender. This court disagreed in Hilton. It agreed in Grady 3. You know, I hesitate to try to adjudicate that disagreement here today. Our position is, and always has been, that merely being registered as a sex offender does not reduce your expectation of privacy compared to someone who is any felon, you know, or frankly, any free citizen. I mean, but even if you just want to do an apples to apples on felons, a person who has been convicted of a sex offense and has to register is subject to the same level of, has the same privacy expectation in their bodily autonomy and their movements as someone who was convicted of, you know, felony larceny.
How does that fit within the framework of the proof of the efficacy of SBM in terms of a sex offender and aspects related to that person's potential lifestyle?
I mean, I'm not quite sure I understand your question, Justice Morgan. Are you suggesting that sex offenders are sort of categorically different as a class from other felons?
Well, in terms of what has been shown to be the efficacy of SBM, which has been established by our case law, that in terms of talking about an expectation of privacy being reduced, while you say you look at sex offenders as any other offenders of a felonious nature, my response to that was, if you could assess for me how that would be relative to the efficacy of SBM in terms of a sex offender and what has been shown to be some effectiveness of SBM relative to sex offenders.
Okay, so assuming, for the sake of argument, and that SBM has some efficacy, and perhaps I should do more than assume, considering that Hilton actually, in fact, says that it has some efficacy based on the legislative findings and some citations to studies. The efficacy is one thing. The expectation of privacy is sort of the other half of the balance, and you know, it gets a little difficult because sometimes in a balancing test you're kind of asking, is the line heavier than the rock? Is the line longer than the rock is heavy? It's there can be some sort of, you know, some weirdness in that interplay. But if you have some efficacy, you still are looking at the nature of the intrusion. I mean, if SBM was 100% effective to prevent all crime, that doesn't necessarily mean you could put an SBM monitor on every convicted felon for every crime forever. I think that everyone would agree that that is probably an unreasonable search. You know, so the fact that it may have some efficacy is only half of the equation. You really have to look to the other half, which is, you know, the extent of the interest at play. And to kind of, if you'll allow me to kind of take it from the theoretical to the actual, to this case, to the facts of this case, let's assume that SBM has some efficacy. Under these facts, there's no point to it because there's no risk to recidivate in the first place, or there's low risk to recidivate in the first place, and we can't predict the future with certainty, but the state's own instrument says that it is unlikely Mr. Griffin will reoffend.
Can I also ask you about the issue of efficacy as it relates to this case? If the studies from California relied on in Hilton and relied on in the new statute were studies of the use of SBM while offenders are on post-release supervision. Would that tell you anything about the efficacy of someone like Mr. Griffin, who is no longer on post-release supervision?
I don't think that that data would be useful, no, Justice Earls, because you're just, I mean, I'm not a data scientist, but it seems to me that people who are just out in the world completely unsupervised versus people who have a probation or parole officer checking up on them every few minutes might have, they might be different sets of people just demographically. They have different incentives. Their lives are just different. So merely because the data in a California study shows that monitored individuals, that it had a deterrent effect for monitored individuals in California doesn't mean that unmonitored individuals in North Carolina, that the data would show that. And as far as I know, we don't have any data in North Carolina, even though the state has been collecting this data now for almost a decade and a half. It has never once in any of these cases produced any sort of proof that North Carolina's program does anything.
Mr. Grant, can I ask a follow-up from one of the questions that you were talking to Justice Morgan about the expectation of privacy? You referred to a sort of disagreement between this court's opinions in Grady 3 and Hilton about the degree of diminution of expectation of privacy. And my question is whether, aside from the opinion in Hilton itself, is there any authority out there that you're aware of for the proposition that there is a diminished expectation of privacy in someone who is no longer in a relationship with the state of supervision?
I am unaware of any case that says that you have again, an appreciably diminished expectation, a meaningfully diminished expectation of privacy merely by virtue of being a convicted sex offender.
So what do you say about Bowditch?
So Bowditch, again, is about the civil regulatory nature of this program and whether it was, in Bowditch obviously is about ex post facto and whether this is punitive or merely regulatory.
There's a sentence in there that says, and I will quote it, "It is beyond dispute that convicted felons do not enjoy the same measure of constitutional protections, including the expectation of privacy under the Fourth Amendment, as do citizens who have not been convicted of a felony."
Well, and I stand corrected. There is at least one authority that says that convicted felons have a lesser expectation of privacy for Fourth Amendment interests. But again, I at the risk of, I want to get this back to this case, because if this is a situation where the interests that justify SBM, whatever they may be theoretically or facially, simply don't come into play under these facts, then you have a case where SBM is unconstitutional as applied. And the analog is a case that is discussed in the Grady 3 dissent. It's a case called Brit versus State. And in essence, in Brit versus State, you had the possession of a firearm statute was challenged by a plaintiff who was convicted of a nonviolent drug offense. And he made several arguments. Among them was the facial and as-applied validity of the enactment as applied to him, a nonviolent felon. Court of Appeals basically rejected all of the plaintiff's arguments on appeal, said that this is rationally related to public safety, and there's no constitutional issue. It was appealed to this court, and a majority of this court left the facial determination of the Court of Appeals undisturbed, but held that the possession of a firearm statute applied to the particular plaintiff in that case was unconstitutional as applied, because the justification for the possession of a firearm statute, i.e. public safety, keeping guns out of the hands of people that have a felonious history, simply didn't apply to Mr. Britt, who again was a nonviolent drug offender whose crime didn't involve guns in any way. And so it's very analogous in that you have a fundamental right, in that case, the right to bear arms under our state constitution, and in this case, the Fourth Amendment right to be free from unreasonable search and seizure. And you have a broader enactment which may on its face be constitutional, but then when you actually look at the specific facts on the ground in an as-applied challenge, you find that the justification that would otherwise support a facial determination kind of fritters away, and you're left with an unconstitutional enactment as applied to an individual, which again is what we believe we have in this case.
Can you also address, as applied to this case, the impact of the fact that there's no opportunity for meaningful judicial review of this order for 30 years?
Yeah, and that kind of dovetails a little bit, I think, with the discussion of what the recent change in law, what effect that has on this case. And the short answer is it doesn't really have any effect on this case, on the law of this case. I will concede that at least on its face from the text of the statute, and again, it's not entirely clear to me that it wasn't just an oversight, but individuals in Mr. Griffin's position do not have a right to judicial review of their orders. Whereas this
That's not what we said in Hilton or Strudwick, correct?
No, in Hilton and Strudwick, I think the court is in agreement that there's no, are you talking about the 60B mechanism?
Yes.
Yes, okay, so as a statutory matter, individuals do not have a right to judicial review under the new statute when they are in this circumstance. You're correct, Chief Justice Newby, in Hilton, there is basically an adoption of something that has kind of been percolating at the Court of Appeals for a few years, which is, well, isn't a 60B motion a way to get the case back in front of a court? And if that is a remedy the court has established, then that is a remedy the court has established. As a matter of the new statute, there is no right to judicial review. There wasn't under the old statute, there isn't under the new statute because Mr. Griffin fits in this kind of, I guess what I could call a donut hole, assuming it wasn't intentional. So there's no right to review this over the next 30 years, except, as you suggest, Chief Justice Newby, to file a Rule 60B motion and argue that the search is now constitutional. I would note, I think the state accused us of advocating for some judicial legislation. That is not what we have advocated for. I merely note that under the new legislation, every offender gets 10 years. It doesn't matter what the nature of the crime was, the nature of the victim, what category previously or currently they fit into, where they score on the static 9. Everyone gets at maximum 10 years. And everyone who's previously been ordered to lifetime gets a maximum of 10 years. They just go into court and the statute seems to suggest it's an automatic remedy. What we have said is that given that the General Assembly seems to have passed an enactment which recognizes that incredibly long periods of satellite-based monitoring are of suspect constitutionality, this court should take that legislative determination into account in determining if there is some lesser remedy at play in this case, for instance, limiting satellite-based monitoring to 10 years, as would be under the statute, again, were Mr. Griffin to fit into the statute. That's not asking the court to create a remedy or to amend the statute, just asking the court to view the totality of the circumstances in the as-applied challenge through the lens of the determination that our General Assembly has just made as to what constitutes an appropriate search for these types of offenders going forward, and for most of them, looking backward.
Well, if the current law still applies, then what would be the mechanism, theory, or rationale upon which this court would, as I'm hearing you say, comply with the spirit of the incoming law and have this to be a duration of no more than 10 years of SBM monitoring?
Yes, I think that is what we are saying, Justice Morgan. If we're not saying that we need you to rewrite the new law to give my accepted client relief, I'm just saying that in view of the new law, which represents a legislative determination about the appropriateness of these searches, and considering that it was explicitly passed in response to the Grady 3 decision, is sort of, I would posit, is sort of the General Assembly recalibrating what it believes to be a constitutional reasonable search in these types of cases. I think those are facts that this court should be deferential to in determining whether the as-applied challenge in this case could be limited to, for instance, 10 years.
Yeah, my inquiry, though, was, and I'm seeing your time is running low, my inquiry was, how would we go about doing that if the current law is still in effect? What would be the legal rationale upon which to premise that if the current law is still in effect, and to integrate that with what you say we should be encouraged to do in light of the new law?
Sure. So the analysis would be that the old law applies to this case and will continue to apply to this case in perpetuity. Mr. Griffin has raised an as-applied challenge, arguing that the 30-year search he's currently subjected to is unconstitutional as applied to him. This court could find and conclude that the search is in fact unconstitutional as applied to him, and make a determination that 10 years of satellite-based monitoring would be reasonable, and use as evidence for that legal conclusion what the General Assembly has just put out in the form of Senate Bill 300. That's kind of how the analysis I think the court would have to go through to do that. And that doesn't do violence to it does violence to the old statute as applies to Mr. Griffin, but it leaves the old statute fully intact facially. It not only doesn't affect the new statute, it actually sort of respects the prudential and legislative judgment made by the new statute in reducing the period to 10 years. So it would be a way to sort of harmonize these kind of disparate things and come to a conclusion in this case that is sensible and again sort of respects the divergent precedent and the divergent statutory schemes and answers just the question that is before this court, which is all it has to answer, which is Mr. Griffin currently subjected to an unconstitutional search? Our answer to that question is yes, and being short on time, unless there are further questions, I'd simply ask that this court affirm the Court of Appeals, affirm and modify to the extent necessary the determination of the Court of Appeals, or dismiss the state's petition as improvidently granted. Thank you.
Thank you, counsel. Rebuttal.
Just a few points briefly. The discussion about the fact that this data is collected, reference to the Jones concurrences, the Carpenter opinion, and the court's discussion, the majority's discussion in Grady 3. There's no testimony here. There's been no testimony that I'm aware of in any of the cases, with the possible exception, I think there was a mention in Strudwick, of what is done with the data. No one has testified that the location data, other than for purposes of monitoring the individual's location, is mined for information about what they're doing, how long they're there, why they're there, or any other facts about the circumstances other than they are at X location on X date at X time.
Is the relevant issue what is done with it or could be done with it?
Well, I think the relevant issue, if we're looking at the circumstances of this case, is what's done with it. If the broader concern is what could be done with it later.
And help me understand that, because the issue, as I understand it, is that we are to balance a number of factors, one of which is the extent of the intrusion. Mm-hmm. Are you suggesting that we only look at what is actually done with the information rather than what could be done with it? If that's your argument, then how does that square with Carpenter?
My argument is that it's speculative to consider what might be done with information.
Is the analysis in Carpenter speculative?
I don't recall the discussion in Carpenter, Your Honor. I'm sorry, I'm not prepared to answer that question.
That's always a fair answer, Mr. Finarelli. I've had to give that one.
I don't want to guess what Carpenter said. I do remember that Carpenter built on U.S. v. Jones for the proposition that, the storage of that cell site location information data was troubling. But I don't recall whether there was testimony there about what was done with it as opposed to just it was collected.
Fair enough. Thank you.
I think the other point that I would like to make briefly is, the discussion from the defendant that, well, if the state's interest is to prevent and solve crime, SBM would not have helped solve or prevent Mr. Griffin's crime here. And I think that misses the point. It isn't whether it would have prevented that crime, it's whether it would prevent future crime. If he has a satellite-based monitoring device, attached to his ankle, as most of them wear, it would be an indication. It may be something that sexual partners don't act on, dating relationships, they overlook it, or that he may not be forthcoming with why he may be wearing that monitoring device. But if it prevents people from interacting with him, even if he is strictly limited to, and we're going to assume he's strictly limited to sexual crimes involving children of women he's in the home with, then I think that's too narrow a focus of what the purpose of the SBM will do and the deterrent effect it may have in preventing any future sexual offense, not preventing a recurrence of the exact crime that he was convicted of in the first place.
So are you arguing that it's functionally the equivalent of a scarlet letter that gives people warning? And is that, go, I'll let you.
No, I'm not saying it's a scarlet letter, but I think it is designed to, I mean, it's not something that's implanted. We're not at the point where, we're implanting this device into someone. There is an aspect of it that it is visible and that it is observable. And so, I mean, whether you want to characterize it as a scarlet letter or simply an indication of this person poses some risk to you by virtue of wearing the device, then I think it has that potential to signal to people that, that signal.
And so, oh, I'm sorry.
So, no, do you consider whether it prevents the whole universe of any potential offenses, or one that this particular defendant may have some risk of committing?
Well, no, I mean, the device itself may have, may cause suspicion of people who are just interacting in the general public. The recidivism that we're concerned about in these cases is recidivism for committing subsequent sex offenses. So, I mean, it may have a deterrent effect for crime generally, but if the circumstance of offense that the defendant would ask you to say this is limited to, it will only work, it wouldn't have worked, excuse me. It would not have worked here to prevent Mr. Griffin's original crime. If you recreate those same circumstances, but he is wearing a satellite-based monitoring device, it may be that it prevents that crime if he is inclined to do so. Now, understand that the static 99 rating was moderate low, which suggests from that standpoint at least that there's a moderate to low risk to reoffense. But I think it's unfair to say that because a satellite-based monitoring device would not have prevented the crime that he committed, that ergo it never prevents any crime at all and thus serves no deterrent effect.
Well, when you say no crime at all,
No sex crime at all.
but doesn't it, is the state's position that it doesn't have to be one that this particular defendant has been shown to be at risk of
Well, no, it wouldn't, because a risk of recidivism, and I'm not aware of any studies that have been submitted to this court or any of the Court of Appeals opinions that I've handled in the past, where the specific crime is the crime of conviction is the only one we have to be worried about the offender committing in the future. It's a risk of recidivism for sex offenses. That's what the static 99 measures. It's not risk of recidivism of committing the same index offense that got them convicted and subject to the static 99 in the first place.
Right, and in this case, that assessment was indeterminate or low,
It was moderate to low, yes.
but not very determinate.
I mean, on the continuum, I mean, it fell where it fell. It's a moderate low rating.
But so I guess if the wearing of the device would prevent this defendant from assaulting people on the Greenway while he's wearing shorts, would that have a bearing on its efficacy here?
Well, see, but then we may be getting into the it may help solve the crime deterrent effect. I mean, there's, not the deterrent effect, there's the court in Hilton has recognized both the deterrent effect and the assistance in solving crimes. We've been talking about the deterrent effect up until now. If in your scenario, Justice Hudson, Mr. Griffin assaults someone on the Greenway, if his defense were it wasn't me, I wasn't there, the static 99 could help inculpate him and say, nope, you were there. Here's the time data that says that you were in that exact location at the exact time complained of. It may also exculpate him. We can be proven that he was not there and that his alibi makes sense. So it has the function there of solving crime, which was one of the same purposes that this court recognized in Hilton. Unless there are any further questions, we would ask that the court affirm the decision of the trial court and reverse the decision from the Court of Appeals. Thank you.
Thank you, counsel. Thank you to both counsel. Madam Clerk.
Well done as usual, Joe.